obviously people who deal with a theft or something like that, where their lawnmower was stolen, they're anxious to maybe get some restitution or get it behind them. They're not always as involved. But if someone was violated with violence, people tend to be pretty available and not be too hard to ascertain their whereabouts. Obviously, as prosecutors, as trial lawyers, we are wanting to stay in contact and honestly get to know victims best we can.
Welcome to the Herlihy Family Law Podcast, your trusted source for expert insights on navigating family law matters with clarity and care. Whether you're tackling tough decisions or seeking guidance for your family's future, we're here to help. Let's get started.
Hey everybody, welcome to the Herlihy Family Law Podcast. I'm Anna Eden, one of the associate attorneys here at Herlihy Family Law, standing in for Allison today. And we're going to be talking about something that can feel pretty overwhelming and confusing for anyone experiencing it for the first time, which is, what happens when you are the victim in a criminal case. Joining me today is Stuart Lang with the Mobile County District Attorney's Office. Stuart is going to help us understand what the criminal case process looks like from a victim's perspective and what victims can expect along the way, and some of the things they can do or avoid doing that may affect their case. Stuart, thank you so much for being here and agreeing to do this with us today.
Yeah, good morning. Happy to be here.
Let's kind of start with the beginning of a criminal case. If someone is the victim of a crime, what does the criminal case process typically look like, from the initial report through the resolution of the case?
Well, obviously, crimes vary. Victimhood varies based on the crime. There's a lot of variables that take place from the moment a crime's committed, police respond, or sometimes police are never even called, and people are forced to report it at a later date. So from a perspective of a victimhood of a violent crime, even as small as a harassment charge, I believe most of the time the first thing that happens is police will get there and take the statements. They will talk to you, process information that you have as long as evidence, take eyewitness testimony if there's any that was there present. There's really no blueprint to how these things go, and they track through the court system depending on charges. Obviously, we deal with homicides all the way down to the lowest level crime. So should it be a homicide, there will be victim advocates with the victim's family. And if the victim is still, of course, with us, then there are measures in place such as the Penelope House and the Child Advocacy Center and other victim advocacy groups that help, as well as the people in our office who are victim advocates that are tasked with helping you through every single part of this. The first step would be we'll be identifying the perpetrator of that crime, and then hopefully finding where they are, taking them into questioning, and likely charging them with whatever crime is applicable. We would then go through arraignments and probable cause hearings to kind of let a judge determine if the police and the district attorney's office on the right track with whatever crime may be. It would then go before a grand jury, which is a jury made up of civilians who would also be testing the merits of the case based on the evidence presented by the police, and as well as sometimes the victims of that crime. And then if the grand jury then signs off on it, it's called a true bill. And it then goes to what we call in Mobile County Circuit Court, but is basically just a jury trial court to be presented for either a potential plea, disposition, or presentation to a jury of 12 citizens of our county who will ultimately determine the fate of the accused and the evidence that's been presented by the victim and the police. So it is a long process. We have tried to fast track it as best we can, but obviously it comes to a halt sometimes, and we have to pick up where we're stopped. But that's a fast explanation of something that usually takes years to procure for victims of crime. But here at the DA's office, we try to expedite as fast as we can, but also without losing the thoroughness that's required by law.
You talked about how y'all have victim advocates, and then y'all kind of partner, I guess, with people at Penelope House for victim advocate services as well. Is there any specific role that the district attorney's office plays within that process, from reporting to resolution? And what kind of interaction specifically should a victim expect to have with people that work at your office, at the district attorney's office?
Sure. And this is a very, very big part of our office, very big part of our job. All prosecuting bodies in this state and throughout the country, there are very, very specific laws on how to interact with victims and to keep them up to date and up to speed on what's going on, and also interact with them should a disposition of the case, a plea, or any type of changes to the case. Victims having knowledge of it, I should say, more than being able to decide all the time. But they certainly need to have knowledge and be up to speed on what's going on with their case. Sometimes victims are hard to find. They don't always, stay in one place. Like I said earlier, it takes a year or two to run through these cases sometimes. So when people move, people change phone numbers, people do certain things that prevent us from being able to really get in touch with them and find them and keep track of them. But we do have partnerships with the Penelope House. We have partnerships with many different, either domestic violence, depending on what the charge is. There's specific groups that like to be involved in it, like to help. They will help they'll help from the night of the incident all the way to the jury trial. They will help find housing, clothing, safe spaces for people who are actively trying to hide from their abusers or their people who have violated them. Our office, district attorney's office, is always trying to help either secure housing or secure ability to communicate with potential victims, as well as ensuring no contact orders are followed against the perpetrators while the case is still pending, and sometimes perhaps afterwards during the disposition of the case. But our office is very much involved every step of the way, again, from the charge all the way to the verdict in the trial. We recognize that we are just a vessel for the victim to get justice for whatever wrong has happened to them, and we want to make sure that they are made whole as we possibly can anyway, with whatever it is that's happened to them, that they're the ones that were brought here against their will. So we want to make sure they're taken care of. So.
I'm curious, within the district attorney's office, y'all have a variety of prosecutors on your team. And is it the responsibility of the prosecutor to maintain contact with their victims, or is it more of a collaborative effort with staff and any other kind of support that y'all have within the office?
It falls on both categories. It falls mainly on the prosecutor, though, to make sure that, and I'm speaking more to violent crimes here, obviously people who deal with a theft or something like that, where their lawnmower was stolen. They're anxious to get some restitution or get it behind them. They're not always as involved. But if someone was violated with violence, whether your loved one was murdered or there was a robbery or a burglary or a sexual component to an assault, or just an assault in itself, people tend to be pretty available and not be too hard to ascertain their whereabouts. Obviously, as prosecutors, as trial lawyers, we are wanting to stay in contact and honestly get to know victims best we can in case we are, in a position at a later date to put them on the stand, testify in front of a jury. We want to know that, what their personality is, what their temperament might be, should they be cross-examined by a defense counsel. So there's that aspect of it, but also, of course, the human aspect of wanting to make sure that they are involved. So myself and other prosecutors in our office are tasked with it by the Victims' Rights Act, but certainly the staff here and our victim service advocates are active and just keep in contact. And we're in court so much, it's hard for us to always be available for victims, but
I can imagine.
But we keep an active communication line the best we can. Like I said, it's not always perfect and it's not always easy, and we're not always delivering great news that they want to hear. But
I think that's any lawyer.
Right, absolutely. Yeah, it's not always, unfortunate. It's always can be bad news, unfortunately.
From a prosecutor's perspective, what are some of the most important things that a victim can do to help law enforcement or yourself build a strong case?
I think the first thing you can do, and the thing that surprisingly it seems to be the most difficult sometimes, is to just be honest. Just from the beginning, if we're going to pursue a felony charge on someone, if you've been violated in any way, I think being dishonest from the jump is going to make your case weaker and weaker as time goes on. You're going to be seen as somebody who will manipulate your story. We're constantly dealing with cases where a drug deal goes bad, and then it's a murder that takes place, or a robbery, and then the victim or whoever's testifying is not wanting to admit that there was illegal activity going on that led to the felony act. It's very frustrating sometimes as a prosecutor to have to pull information out of people that our concern is not whether you were buying weed or whatever. We're here for a much bigger cause, and the more accurate and more truthful your testimony is, the more, I would say, the likelihood of your case going well, and the case of whatever we're doing being successful at trial, because a jury will sniff that out immediately, and as will we, and it will not help your case at all to try to pretend that whatever the circumstance was, there's always whether it's domestic violence, whether, say, the wife started a fight, but then the husband took it too far and now the police are involved. She'll say that she didn't do anything, and then later she'll say that, okay, well, yeah, I did start something, or things like that. It's just, it's weird to say that, but honesty is the first step, and always the first step. Obviously, evidence collection is another part of our case, is that people try to either do their own evidence collecting by tampering with evidence and try to get it and do their own investigations, and it kind of ruins certain things for us. But honestly, if you could just be honest from the beginning with whatever law enforcement agency you come in contact with,
yeah,
way ahead of the curve at that point.
Yeah, I mean, we deal with that too, practicing family law, right? Like,
Sure.
Honesty is the best policy for a reason, and
It's going to come out.
Yeah, I mean, and we encourage clients very often, even if your truth is still considered bad, still tell it, because it's going to hurt you way more in the long run if you're caught in a lie. I think that's another thing that can just go across the board for lawyers and their clients. But you brought up evidence. What can victims do to make an effort to try to at least preserve evidence that they may have, like text messages or emails, voicemails, pictures, any kind of communications or documentation that they may have of what happened? What can they do to help preserve that for y'all and for law enforcement that won't cross over into tampering?
Of course. Yeah. I mean, ideally, things like text messages, emails, photos can be preserved, and we can go back and get them at a later date. We have the subpoena power to go, and we're constantly subpoenaing Snapchats and Instagram messages and things like that we can preserve. If a victim is trying to initiate charges, obviously getting a hold of them, sometimes you can delete some messages that you sent, and it can paint a picture against somebody else that's not particularly true. And then we would subpoena Instagram records or whatever it may be. We see that you've manipulated the truth a little bit with your evidence that you presented. But obviously DNA, fingerprints, these kind of things are always so important. We deal with people and we also deal with delayed reporting a lot, and especially in sexual assault cases or domestic violence cases, where DNA is lost or the DNA is not preserved. So that's a whole other story or a whole other podcast probably, of delayed reporting on certain events in life. People make decisions for whatever reasons they make, but evidence preservation in all aspects of the law, I think, is huge. And my advice on that would be to, again, be honest, not manipulate it, but also just allow someone who knows what they're doing, if you can, if possible, get in touch with law enforcement and let them do it over you trying to do too much and potentially damaging your case or appear to be manipulating your case.
Yeah. Well, you kind of already answered this a little bit too, but what outside of the things that you've already described, like potentially manipulating evidence or being dishonest,
Right.
what are some of the other common things that a victim of a crime can do, and even without realizing it, that can make their case more challenging to try and prosecute?
The thing that comes to mind on that would be, and I know you have it obviously in your world as well, no contact orders, protection from abuse orders, people who actively get the court involved in their personal life for whatever reason, and then go and contact that person, and then go and put the prosecutor or yourself into a position where we are now in front of the court and the other side saying, well, judge, my person has not done anything, but you're the person that's supposed to be the abused is now calling and emailing and texting. And again, there's a variety of reasons why people do that and why people decide to engage with their abuser for whatever reason. But things that kind of came to mind as a recent problem that I've had, that I think as far as that would be more realizing it, I guess. But you know what you're doing, and whether you are overwhelmed with emotions and you're making some decisions that you shouldn't be making, that's one thing. Without realizing you're damaging your case, again, evidence manipulation is another thing that we deal with a lot, and just honestly putting, as a victim of a case, depending on what the charge is, you have to realize that you're not on trial as the victim in a case, but you are 100% going to be judged by a jury or a judge should that go to trial at some point. Your actions, if you're the victim of an assault in a bar fight, and then or go out and you just post in social media pictures of you just drinking and you're acting crazy and you're doing things like that. I mean, it's going to come out at trial. You're going to damage your chances there just by appearing to be somebody who would engage in a bar fight, who would initiate a bar fight. And people make those assumptions every day in court. And there's laws against being able to assume things that are on paper, but in reality, in our heads, things are assumed and things are presumed.
Yeah.
So
sorry, I didn't mean to cut you off. Have you ever encountered, I'm curious, I haven't yet dealt with this before, but I could see where maybe it might be a larger issue for you guys, with cases where there's a no contact order between a defendant and their victim, not necessarily the victim violating the no contact order, but friends and family basically harassing the defendant. Does that affect the courts? Have you ever seen that affect a court's perception of that victim? Is the victim in any way held responsible for the actions of their close friends and family, whether they know it or not? I mean, I think you could probably be proven to some degree if it was like at the behest of the victim, like, I can't talk to this person, but y'all can, so say whatever you want to say. Have you dealt with that before?
The majority of our no contact orders involve a one-way no contact. The judge always instructs that if the defendant is in McDonald's eating a hamburger by himself and then the victim comes in, even though the defendant was there first and not causing a problem, the defendant has to leave. That's the example that we give to everyone, that you are to flee from contact.
Gotcha.
In the days now of social media and obviously text messages, phone calls, people are accessible now more than ever. And so, of course, the victim's families initiating contact with defendant's sister, the people, our town is big, but not that big. People come in contact with each other all the time. And I mean, it's definitely a big problem. It's led to many show cause hearings in our world as to why a victim shouldn't, a victim's family is goading the defendant or the defendant's family. It's really turns into family warfare in a lot of these cases, or street warfare, depending on what street you live on, and things like that. It's just kind of then the mutual no contact, as we call it, which is, it seems silly to say. It's more like, just, can you be an adult and just exist in society, more than thing. But mutual no contact orders go out a lot on our side to basically the next person that causes the problem, that gets on social media and makes a post about this incident, whatever the case may be, is potential contempt charges coming that way from the judge, for sure.
I feel like we probably see more of that, or the most of that kind of behavior, when we are handling PFAs. Because most of the time, I would say like close to maybe 70 to 80% of the time, individuals that file PFAs or have, PFAs filed against them, they end up litigating that without an attorney. So when you get the opportunity to go down and observe one of the PFA dockets, or, you have court that same day and you have to sit and wait through it before your case gets called, it can be really interesting to see the dynamic between the individual that filed the PFA and the person that's been accused of the behavior. Because a lot of times I feel like I'll see so-and-so saying, well, their sister has called me, their brother has called me, their mom has called me. And the person who filed the PFA hasn't necessarily violated the terms of it, but their family has. And, it's just, the whole dynamic is pretty interesting. I feel like there is a problem to some degree where victims do pursue criminal charges or, some kind of no contact through a family law case, and they end up violating that to some degree.
Yeah. And it's always usually at the behest of the victim, and people wanting to do it for the victim. Like it's a team thing,
Yeah.
and it really loses sight, and it really waters down the reason a PFA or a no contact order exists, which is the bigger picture of what incident led them to that point.
Yeah. I mean, it begs the question, are you really afraid of this person?
Right. It doesn't show fear. It doesn't show a need for protection. It shows you're just out there retaliating against somebody and using the court to do it, which I think is where the courts really get their frustration from, and really start holding people in contempt. And then now you went from the victim to having a much bigger problem on your hands than filing a PFA.
What, segueing kind of into social media and communicating on social media, what should a victim know about posting about their situation on social media? Is that helpful? Is that hurtful? What is y'all's general advice?
I could never, ever see it being helpful, ever. It's been a constant plague in our office for years, since social media probably even started existing. Like I said earlier, people are just free to say whatever they want now and put it on the internet, make videos. They're not using fake accounts or fake names. It's like they are proud and loud, and they want to tell you by name what judge or what defense attorney or what defendant or prosecutor is not doing what they want. And we have that conversation as soon as I meet a victim or a victim's family. Memoriam type post of people who are homicide victims, of course, are going to be expected, and that's great, but stick to the deceased for now. You don't have to invoke the accused shooter or the accused rapist or the accused whatever just yet. It's not going to help. I don't know what people think it's going to do by posting it on Facebook or whatever they end up doing, but it certainly is going to taint our case. It's going to show, like you said earlier, it doesn't show fear, it doesn't show sorrow, it doesn't show anything. It just shows that they're kind of feeding into the frenzy that can come out of something like that. But it is a part of the grief. I get it.
Yeah. We typically have a hard and fast rule that we try to tell clients, and that is just stay off social media.
Sure.
Stay off of it. If you're going to post something about your kids, that's fine, but don't get on there and start sharing a bunch of stuff about your co-parent, or even subliminal memes or anything like that about what it's like to co-parent with a narcissist, because I mean, whoever wants to find it is going to find it, and they're going to use it against you.
Well, that's another thing.
Yeah,
subliminal stuff is always, people come in and say, look, this is what he posted. And I don't know what that means, but they're saying that it's a direct threat or it's a whatever. And I'm like, you're feeding into whatever we don't want. So even if it's a subliminal message.
Yeah. We are a family law firm, so a lot of our listeners are probably dealing with, or might be dealing with, divorce or a custody dispute or a protection order, any kind of family law matter. And what specifically should victims know when they've got a criminal case and a family law case that are overlapping?
I think it goes back to, at least this is the prosecutor saying this, but let us get the criminal part out of the way. And I know there's always when we have these overlapping cases, it seems like the criminal court and the domestic court are just both at a stop signs and looking at the other guy like who's going to go first kind of situation. And I think the domestic world, I think, at least from my experience, I've kind of deferred to get the prosecution over with first. But
we have to.
It's not always the case. It's not always the case, and there's always maybe a reason to expedite on the domestic side, depending on what the overlap is and depending on what the charge is in criminal court. If it's a domestic violence situation, or if it's a theft of property, or kidnapping, or could be a number of things. But I do feel like there's a need to. I don't know how the domestic side would work at knowing that there was a pending domestic violence strangulation charge or whatever the case may be on the other side. That would be hard for a domestic judge or the domestic attorneys to be able to properly move forward. But it's always a cloud. It's always a cloud of domestic issues that are hanging out if there is a case pending, or the divorce or child custody issue or whatever it may be.
Yeah, there's case authority.
From my perspective.
Sorry. I was going to say there's case authority, and the law is really clear that, and we have to explain this to clients when they come in. And part of the reason why they've come to our office is a few days before their spouse hurt them and there was a domestic violence incident. The police have been called, and a warrant's been filed or issued, but they haven't been picked up yet. And we have to be really careful with what we do. And we have to explain to them that their spouse still has the same Fifth Amendment right that we all do. And the moment their spouse tries to take the stand in a civil matter to testify about any of the underlying issues that could be related to that criminal matter, that prosecutor can take that transcript from the civil case and use it against them in their criminal case. So, 9 times out of 10, your divorce is going to get stayed if there is a criminal case that's related to your underlying divorce or your custody dispute or whatever it may be. Why you've come to see me. If there's been a criminal action, your case is going to we're going to get it started, and we're going to try to get you relief on the front end, but it's not going to be over with until that criminal case is over with. And, that's when the benefit of being able to get ex parte relief comes in if there's a true emergency. But, we're always going to play it safe, because we certainly don't want to be the ones to have put somebody's constitutional rights into question. And that, would ultimately hurt the criminal case for our client.
Well, we worry on our side about retaliatory things in that nature, charges being put on somebody who you're wanting to divorce or get custody from. And so it takes us a little time to sniff out, is this, make sure this is legit, make sure everything here is above board, and really, in a domestic case, unfortunately on our side, it's usually he said and she said. There's only 2 people that are in the room when it happens. It makes it prosecution fast, but it also makes it difficult. But like you said earlier, there is a risk to putting anything on paper or putting too much testimony on paper before a criminal charge in civil court. If the criminal charge is still pending, it can it can jam you up pretty bad.
I don't know if you could, or if you'd be able to answer too much about this, but I think it would be important for listeners to know, specifically because a lot of the crimes that we typically deal with in family law have to do with like a person-on-person violence, domestic violence, harassment, assault, sometimes sexual assault. What can victims do so let's say, for example, the type of charge is one that might not necessarily be a felony. It's just a misdemeanor domestic violence, and it's a first-time offense.
Sure.
What court is that defendant going to be prosecuted in?
So that depends on where you are when this occurs. So if you are within the city limits of, say, Mobile or a municipality that has a municipal court system, you will go to city court and you will deal with that through a municipal judge. If you are in Mobile County, if you are in the county and the sheriff's department responds, or even in a strange circumstance, maybe the state troopers are nearby and they respond, then the state of Alabama will have jurisdiction, and then you'll come to the DA's office court. You'll come to district court here in Mobile County and see a district court judge. So it's just all going to depend on, obviously, the severity of what takes place in that incident, what's chargeable and what's not chargeable, and then where you are located when the incident takes place. But like you said, the charge will be the same no matter what. It'll be the same level of misdemeanor or potentially felony, but what court you're in will be dependent on your location.
And those misdemeanor charges, right? I may be wrong. You can correct me, but if they're in municipal court or if they're in district court, if they're just misdemeanors, they're not necessarily going to have a jury trial, right?
Correct. You're not entitled to a jury trial. Yeah, you would have a bench trial in front of a judge where you will present your evidence. You'll be assisted by a prosecutor, or you will be assisting a prosecutor, either a city prosecutor or a state prosecutor. And yeah, you will present the cases to a judge who will make the determination. He or she will decide guilt or innocence. If the accused is convicted of any of the charges, the misdemeanor charges, at that time, the person who is convicted will have a chance to appeal up to a trial court. And then at that point, they will be able to go in front of a jury on appeal from district court, de novo, as we call it. It'll be a brand new trial. It won't matter about your conviction downstairs. If you're challenging it and appealing it, you'll go upstairs and you'll get a fresh start. The jury will never know that you were convicted of harassment or whatever it was by a district court judge. It happens every day in this courtroom or the courthouse, and things are appealed up and settled either before a jury or leading up to a jury trial. But most of the time, they will be handled in district court or in municipal court, and will be in front of a judge.
Well, to kind of wrap things up, I have one last question for you. If someone has recently become the victim of a crime and they feel overwhelmed by the process and what's going to happen next for them, what is going to be the most important piece of advice that you would give that person?
It would just be to communicate with someone you trust. It doesn't have to be the police. It doesn't have to be a parent. It doesn't have to be anything like that. It just needs to be somebody, an outcry witness for you, someone that you trust, that will back you. Obviously, if it's a major felony and you've been beaten up pretty badly, and there's going to be a law enforcement involved, and they'll get it rolling for you. But the amount of people who are victimized but then hesitate, or they don't want to go forward because they are worried that they'll be perceived one way or the other, and they'll be somehow become really the defendant in that case. I deal with that daily, and I try to tell people that you are not here for any reason. You're not in our office right now for any other reason other than you were victimized by someone else. And I think to feel overwhelmed is natural, but to feel alone shouldn't be the feeling you have. You certainly have plenty of advocates in this town and in this county and in this country that want to help people who are being victimized. I think coming forward as soon as possible, even if you just think maybe you were victimized, talk to somebody about it. Talk to somebody who's in the know about the victimization of whoever it may be, and they'll give you the advice that you're seeking to either go forward with a charge or whatever it is you want to do. But my advice would be not to hold it in, not to question what your gut's telling you that you are a victim of something, if you certainly are.
Yeah. We'd probably echo that too back to a lot of our clients. Just, we have a lot more daily and direct contact with people that we represent. And when people come to us and say, this past weekend, this happened, if there is a serious violent element to it, some of the first things that we ask were, did you call the police? Did you call for help? Did you get somebody else involved? And if they haven't, most of the time we encourage them to do that. You
Yeah.
need to report this, you need to make a record of this, and you need to get help for yourself. It may delay your divorce or your post-divorce issue, but it's really important that you take advantage of the resources available to you and that you try to have this person held accountable for what they did, because it's not okay.
Yeah. People really hesitate. It's really surprising how fast or how slowly people will work through something that's very clearly a violation of their sanctity as a person. But if it's
Your integrity.
exactly, and it's your loved one or your spouse or your parent or whoever it is, and you think, well, I don't want to jump to any conclusions, but your gut's telling you that whatever they did was not right, and it needs to be addressed by somebody. But yeah, I mean, the making a record is, of course, is another good thing that you brought up. Making a police report, if you can get in touch with somebody like that who you can make a record that you didn't wait 3 months to report something, 6 months to report something. You weren't talked into the idea that you had been victimized. You knew it on your own, and you addressed it as soon as you could. Would certainly look better for a case than maybe a late report.
Yeah. Well, Stuart, thank you so much for joining us and helping our listeners better understand what happens during a criminal case and the role that a victim can play throughout that process. For anybody that's navigating a criminal matter alongside a divorce, custody dispute, protection order, or any other kind of family law issue, getting the right guidance and understanding how the two proceedings may intersect can be incredibly important for you. To learn more about Herlihy Family Law and to listen to more episodes of the Herlihy Family Law podcast, you can visit our website, herlihyfamilylaw.com. Thank you all again for listening, and we'll see you next time.
Thank you for tuning in to the Herlihy Family Law podcast. Remember, you don't have to face family law challenges alone. Visit herlihyfamilylaw.com or call 251-432-7909 to learn more.